Well, I know that in the summer, when Attorney General Jeff Landry suggested that Solicitor General Liz Murrill would be the perfect speaker for our October meeting, that we never imagined that she would join us on the same day as another brilliant conservative female would take one step further to joining the highest court in the land. And very well pass out the sanction to the floor for the full vote. And that we would also have another conservative female, our own Jamila Landreneau, running for First Circuit Court of Appeals. So Louisiana conservative women are making their mark on our country. Amen? Amen. So, in 2016, Attorney General Jeff Landry appointed Liz Murrill as the first Solicitor General for Louisiana. She has more than 25 years of experience working in diverse state and federal government legal environments and has experience handling complex litigation, state and federal appeals, and complex government transactions. Liz most recently served as the Louisiana Department of Justice's Director of Administration, and before that, Director of the Civil Division. She previously served former Governor Bobby Jindal as Executive Counsel and was Executive Counsel to the Commissioner of Administration. She was the United States Supreme Court Judicial Fellow and taught appellate advocacy and legal writing at the Louisiana State University Law Center for more than 10 years. Liz earned her bachelor's degree from Louisiana State University, law degree from the Louisiana State University Law Center, where she was editor-in-chief of the Law Review, and a Master of Laws in Alternative Dispute Resolution from Pepperdine University's School of Law. She clerked for U.S. District Judge Frank Pavlikova and Louisiana First Circuit Court of Appeal Judge Melvin Shortis. Liz has argued cases at the United States Supreme Court, the Louisiana Supreme Court, the United States Court of Appeals for the Fifth Circuit, the District Court of Columbia Circuit, and multiple state and federal courts. Additionally, she has filed briefs in courts across the country on a wide variety of constitutional issues. My friends, we are honored today to have Liz Murrill with us as our speaker. Liz?
Thank you so much for having me and for inviting me here to be with you. It's a great honor for me, and I think if you had asked me back in the late 80s, 1990, 91, when I was in law school with Johanna and Kevin, I would never ever have told you that or predicted that I would be standing in front of the United States Supreme Court where I stood last March and last October. It was just not something that I really ever anticipated in my career. I wouldn't have told you that even 10 years ago when I interviewed with Jimmy Fairclough, who was executive counsel to Governor Jindal at the time, and he asked me why I was interested in the job as deputy, and I said, well, I'm really interested in separation of powers, which is like the most boring answer to a question ever. But it was true, and so we spent, I kind of spent the last 12 years basically working in state government, and it's just a fantastic experience. I love the work that I do. When Jeff asked me to join his team, I was really excited about that, and then he put me in charge of all of our constitutional litigation, which was my dream job. And even then, I couldn't have anticipated that I would be next month arguing my fourth case at the United States Supreme Court. So, it's been a great odyssey. It's been a great privilege. I think one of the most magnificent privileges of my career, though, has been the period of time from November to March when I was preparing to argue the June medical case. And it was that time, and I was running on the mall in Washington, D.C. in early October, just last year, when my phone started to blow up. Because I was getting ready to argue the Ramos case, which is a criminal case involving the Sixth Amendment, and the court granted certiorari in June medical. And we knew that was a possibility. We had been briefing it, and we had been anticipating whether the court would grant cert. but I didn't know that it would happen at that moment. And so my phone starts, just blowing up. So from that point forward, am I too close? From that point forward, it was, I spent virtually every waking moment and some not waking moments thinking about June Medical and preparing for the argument that would be the biggest potential change in the law on abortion jurisprudence since Casey. And so that was a pretty big responsibility. I felt the weight of that responsibility very acutely. And I had the great privilege to have people like Claylee Carpenter text me every day with prayers and bring me food with her team, many of whom are here today, and they brought me meals, and meals for my whole family. Pray for our family, and many of you were doing that at the time, and it was just so uplifting to know that there were so many people here and across the country that were praying. A lot of people pray for a particular outcome, and they pray for, but we never know how these things are going to turn out. We can't control the outcome. I prayed that I would be able to do the very best job that I could, and that God would take the rest of that into His hands, and we would be able to, we would eventually be successful in changing the law and changing the culture around abortion and abortion jurisprudence. So when the opinion came out in the last, it came out in April or May, and we lost. We were all very disappointed. Obviously, everyone who had worked and prayed about the outcome of that case was disappointed. But when we read the opinion, the chief's opinion when you really read this opinion, it looks like he was about to vote with the conservative justices and then potentially changed his vote at the last minute. We really don't know. We don't know how these things work. In the background, in the back offices of the Supreme Court. But the opinion read very much like a conservative majority opinion that was still trying to write, not reverse Hellerstedt, but write a majority opinion with the conservatives. But he had aligned himself with the liberal justices instead. So it was a curious opinion, and now there is a lot of litigation ongoing now about whether his opinion is controlling or not, and whether it actually changed the law, and we are winning that argument. So I guess one thing I'm here to tell you is that we did make a change. We did make an enormous change in the law. These things take time. They do happen slowly, and I think that has been one of the predominant attitudes about the Chief Justice, whether some people ask me, do I think that he's really gone completely off the reservation, and I would never say that. But I do think that he has always openly said that he believes that it is a conservative court, that a conservative approach to the United States Supreme Court is that they are very, very careful and deliberate, and that change happens slowly over time. He was true to that principle, I think, in that way, and as disappointed as I am, I am very grateful that we are now seeing a change in the circuits where his opinion is being treated as the controlling opinion, and that means that our laws are surviving, and that is an enormous, enormous win. I mean, it's hard to describe how many challenges we were defending after Whole Woman's Health v. Hellerstedt came out. I had 5 lawsuits that I was defending on, and one of them included a challenge to almost all of our abortion regulations, including the authority of the Department of Health to even issue licenses and rules and regulations. So it was all on the table, and now it's almost all off the table. So that opinion has had very dramatic change. In fact, that case alone was dismissed. They just dismissed it. They walked away completely from the entire lawsuit. They have dropped a number of other challenges. There was a challenge against our law that requires doctors who perform abortions to be board-certified obstetricians or family practice doctors. That law was being challenged in 2 separate lawsuits. They've abandoned those challenges. So you know, we have now, a lot of our regulations are not as under fire as much as they were. We are not having to spend the money and the time to justify common sense regulations that both protect life, show the state's respect for life, and protect women even when they do make that choice. So we have made a change in the law, and I'm very proud of that. And I think that over time we're going to see this case is going to be a very, very important case in the movement of in the shift of abortion jurisprudence over time. So I thought it might take a little longer to see that happening, but it's happening very quickly. We've already had decisions out of the 8th Circuit, and I believe one just recently came out of the 7th Circuit, the 6th Circuit, a Kentucky case. And I think that's the 6th. And both of those cases said that the chief's opinion was controlling. Our own 5th Circuit opinion came out just 2 weeks ago, authored by Judge Dennis, that said that it is not controlling, and so now we are going to have a big round of arguments, I believe, at the 5th Circuit to see whether they go en banc, which means the whole court, all the active judges on the court. That will then include some of our new Trump-appointed judges who will get to weigh in on whether they think the opinion actually changed what the interpretation is of Casey and the application of Casey, and all of that ultimately results. I mean, while I have to dig into the details and the weeds of how these cases are applied and interpreted and what the history and how the court moves, what that means for us as a state is that more of our laws survive. It means that the actions of our legislature and the people that we represented to make laws and to represent us in the legislature are validated, and they can survive, and they can be enforced. And I think for someone who has always believed in the ability of people to govern themselves, I have always, and I teach this to the Boy Scouts because my children are in Scouts, and I was a Scout leader myself, and I do the citizenship in the community merit badge training for them and the rank advancement about citizenship in the community. And what I tell them is you need to engage. That apathy is the greatest threat to our democracy than anything else, in my opinion, and that they should participate. So it's great being here and seeing and meeting some of our candidates for office at the local level, because at the end of the day, when we self-govern ourselves, it's because we participate in government from the ground up, from the justice of the peace to city council to judges to First Circuit, and it's when we put ourselves out there. I have not run for office since I was running for, I think, the Young Lawyers Council for the Bar Association. So I think it's great to see people that I know and that I respect running for office, and it does take a lot of a commitment to do that. But that's how democracy survives. And so when we see these cases that put responsibility and accountability back at the level where we would think it should be, we're putting it back in the hands of our legislature, putting it back in the hands of the people that are closer to us and more accountable to us in the policies that they make and the laws that they adopt. And I think that's good for democracy. I'm happy to answer any questions that you have, and I can keep talking. I'm never short of words. But if you have questions, I'm happy to open it up and take your lead.
Yes, I think it'd be really interesting for a lot of the people here to just get a really brief general understanding of that June medical case and what it would have represented and the impact on the abortionists here in Louisiana.
So June medical, the issue in June medical related to a law that was passed by the legislature that required abortion doctors to have admitting privileges in a hospital that was 30 miles from the clinic. And so that law was challenged 6 years ago, and it went through a trial, and while it was on appeal at the 5th Circuit, a very similar law in Texas was making its way through the U.S. 5th Circuit. And the 5th Circuit upheld Texas's law. Texas is a much bigger state, obviously, than ours. They're just the number of clinics that they have, the number of women generally that they have, all of their statistics obviously way outside ours. That case they won their case at the U.S. Fifth Circuit. The law was upheld, and that decision was challenged in the United States Supreme Court. That decision became Whole Woman's Health v. Hellerstedt. And Whole Woman's Health v. Hellerstedt was a decision that said admitting privileges don't really have any value, and the liberal justices had the votes at the time for that opinion, and so they interpreted the Casey opinion, which was decided in 1993. And Casey created this balancing, or this, it discusses balancing tests about an undue burden on a woman's right to make this decision before viability. And so Hellerstedt came back and tried to reinterpret Casey. And in doing that, the justices wrote, the majority at that time, wrote this opinion that said that you have to balance the benefits and burdens of the law. Well, that was really not what Casey said. And so but when you have 5 justices that say that that's what the opinion said, now that's what the opinion says, because that's the majority opinion. So they had created this what was argued then as what I refer to as a pure balancing test, like benefits, burdens. This put, as a practical matter, this put most of the policy decision and decision making in the hands of federal judges rather than our legislature. Because now you had federal judges that were second guessing the medical benefit, the policy benefits, the medical value for women, and all of that had been weighed and discussed in the legislature at the time. A lot of people had testified in those hearings. Clearly, didn't you testify in those hearings? Who testified? There were, no, Cindy Collins testified in those hearings. Dorinda Bordley testified at those hearings. Doctors, doctors who had taken care of women who had suffered from basically abandonment of their doctor testified in those hearings. But when you go to the court, now a federal judge is going to reevaluate that testimony and reevaluate the medical value of this choice the legislature has made and balance it against what they perceive to be the burdens of the law, or what evidence they put in the case to show burdens of the law. This was an enormous sea change in how laws had been evaluated, but that's what triggered all of these new challenges to our laws. And when we marched into court on June Medical, I had won the case at the Fifth Circuit, as Texas did before. They upheld our law. They did a little bit of a different analysis. They looked at the facts and the findings that the court had made, and they found that even applying Whole Woman's Health v. Hellerstedt, we should win. And so part of the big fight that we had was our law really that different? Were our facts really that different? Were they different enough for the court to have a different result where our law could survive but their law couldn't? And I think that that put, according to all of the SCOTUS clerks and people who know the kind of insiders or at the court, it put them kind of in debating whether or not we could get the Chiefs' vote. So this was always about whether we could get the Chiefs' vote, because we pretty much knew from prior opinions and from the dissents that had been written in Hellerstedt where Justice Thomas would be and where Justice Alito would be. We predicted where we thought Justice Gorsuch would be. The Chief was really the critical vote in this opinion, and so then we argued the case and we did the best job that we could to explain why our record was different, why our law was different, and why our law actually fell inside a different regulatory structure than Texas's law had. And I tried to kind of urge all of those points. Some of you may have listened to the oral argument, and you can see that I was on the ropes pretty the whole time that I was arguing by the female justices on the court. And so it's very, I think, very, very nice to see that we're going to have a female justice on the court who has a different point of view, has a different voice, sees some of these issues through a different lens. You know, one of the issues, and I know I'm kind of running on from Chloe's question, but one of the issues in that case was this legal issue about third-party standing, which is just it's a legal principle about who can bring a lawsuit and what issues they can raise in that lawsuit in federal court. But for decades now, they have permitted abortion doctors to file lawsuits and assert the rights of women. And so when they sue us, some of them are suing on their own behalf, but over time, they've gradually moved away from that, and most of the time now when they sue, they're suing for women's rights. They're not suing for their own rights because they, as doctors or as economic participants in the system, they really don't have a lot of protection under the law. The legislature gets a lot of deference. But if you can raise a fundamental right, then it's a lot harder for the law to survive. So they are going into court and they are raising the rights of women. And one of the issues that I flagged from the beginning was, why are these people speaking for us? They don't speak. First of all, we don't all have the same voice. We don't all see things the same way. We're not just one big homogenous group that sees everything exactly the same way. And so, and it just seemed curious to me, especially since most of the opinions that have moved abortion jurisprudence forward have been written by more liberal justices on the court, that they would adopt this position that silenced women's voices instead of amplified them, or recognize that we may not all think the same or view things the same way, and instead let women speak for themselves. Well, that issue, you know, we raised that issue in our response to the petition that was filed to try and overturn the Fifth Circuit, and was really surprised a year ago around this time when the court granted cert on both questions, on the question of third-party standing and on the question they had raised about whether the Fifth Circuit's ruling was correct on admitting privileges. And so, you know, it was really, really interesting then because they had something to lose. So just from a strategic standpoint, we now had two competing questions on two different lines of jurisprudence where we could have won, you know, an enormous victory. I was very disappointed to see that in the opinion, the Chief did not really address that at all. He dropped a footnote in the opinion that seemed like he had almost forgotten to write about it entirely. And think about it, because it just said, oh yeah, what they said in pages 8 through 18 or 8 through 16. And so he didn't really address the issue at all. He left that line of jurisprudence intact, and I think we will still come back to that. And I am looking forward to seeing a woman conservative justice on the court that will balance some of that thought process, because I really still believe very strongly that it is not a good thing to stereotype and decide that we all think the same way and view this, especially on this issue, which we clearly don't. And so I think it's important to have a woman conservative justice on the court who can balance some of that debate. And so I'm really excited about Amy Coney Barrett's appointment.
Yes.
Yes.
I know your interpretation of the outcome. What do you believe the outcome said?
I think that the outcome is that the Chief changed. I think he basically overruled Hellerstedt. I think that his opinion under a different line of cases is controlling, and that he has reinterpreted Hellerstedt to get rid of this pure idea of pure balancing. He's put a lot more power back in the hands of legislatures to make those policy decisions and do that policy value decision, and not have a federal judge second guess it. So that's really important. And we are going to eventually, I think, see a case where that question is teed up. I mean, at some point, the Supreme Court's going to have to decide or do something that determines whether his opinion is controlling and whether we are applying this kind of balancing test from Hellerstedt or his view, which gives more deference to legislative judgments. I think that he did change the law. I think the cases that are coming out of the circuits right now reflect that. It will be some time before it finally resolves itself. Maybe not as much time as I thought, since we've got two cases working their way up there now and probably a third one coming out of the Fifth Circuit before very long. You know, what those cases, the way this works is, so far 2 circuits have said his opinion is controlling. The 5th Circuit has said it's not, but then they will go en banc, my prediction is they will say that it is controlling. And now we'll have 3 circuits that say it's controlling. So we'll be waiting to see some other circuits that maybe, you know, aren't as conservative circuits or don't view the law the same way, and they may come out and say it's not controlling. And then we have a circuit split. And once you get a circuit split, you have a much more likely case that the Supreme Court will grant grant a hearing in one of those cases and decide and issue an opinion itself that clarifies or just decides that issue. Well, now we are more likely to have 6 votes, or at least 5, that would say his opinion is at least controlling, or even better, that would say Hellerstedt is flatly overruled. So, you know, that would be the better way to get, I mean, I think it seems to me to be, it would save us all a lot of time and energy if the chief had simply flat out overruled Hellerstedt. He dissented in Hellerstedt. He didn't agree with it. In June Medical, he again asserted that he didn't agree with it. So it was curious that he didn't agree with it, but he was basically reaffirming it, and but at the same time rewriting it. So I think that does have to get sorted out, but at the end of the day, I think they've changed the law.
Could you give any thoughts on how long it would take to reverse Roe v. Wade with a conservative judge on the courts now?
I think, are you asking me whether I think they will reverse Roe, or what the likelihood is of reversing Roe?
The time frame possible?
You know, it's really, that's a very hard question. I don't think it is imminent if it happens. I think them far more, one thing that I think you saw with the chief's opinion is a general reluctance to change jurisprudence that was only 3 years old at that point in time. I mean, it was only 3 years old, and it had been, you know, in a battleground in every circuit ever since it was decided. Roe is a different, I mean, it's just a kind of a whole different animal of a case, and because Roe partly relied on a line of jurisprudence that dealt with privacy rights, that didn't have anything, they had more to do with contraception than to do with abortion, the court has to kind of grapple with some earlier cases that predate Roe. And I think that makes it very hard. I think it's going to be a long time, but I do think that over that period of time, we are going to see a lot more laws that are upheld, where you know, upholding these laws gives a much better opportunity for us to see that there is that there's not a disastrous effect, and it puts a lot of power back in the hands of legislatures. I think that is an important thing too. We don't have to all be the same state. The states don't have to have the same policies. But I think it will be. I think it. I mean, if you're asking me to pin a date, I think it's still potentially 10 years away. I think there will be movement. I mean, that doesn't mean that there wouldn't be a lot of movement in that time. I think there'll be dramatic movement in that time. But you know, one of the statements in, I think it was Hellerstedt, I've seen this in advertisements too, opposing the reversal of Roe, and it's ever since President Trump was elected, there have been a lot of panel discussions and other discussions. Every time he gets to appoint a Supreme Court justice, there are a lot of discussions about, you know, what does life look like post-Roe? And what life looks like post-Roe is that states get to legislate. That's what life looks like. And so you will see some states like New York who basically have taken their hands completely off the wheel and said, we're not going to regulate this at all the way even up to birth. We're not going to regulate it. And Virginia. And then you see states like ours, which are very pro-life and very aggressively attempting to protect and show their respect for the value of life and recognize that the fetus is a person. So you will see that, I think, continue to occur. You will see a battleground in state Supreme Court races. And 3 years ago, I sat on a panel at Americans United for Life with a bunch of very, very impressive women, doctors, several doctors and professors who write in this area. And somebody asked me the same question, and that was the whole topic: what is the post-Roe world? And I said, a post-Roe world looks like a lot of big battlegrounds in state Supreme Court races, because they are already 13 states right now have recognized a state right to obtain an abortion, just since like little row decisions. And that's what Amendment 1 is about on the ballot now. It is a ballot amendment to make sure that our Constitution has some express language in it that says that nothing in this document should be read to find a right to abortion or a right to funding for abortion. And so it doesn't take power away from the legislature, but it does direct judges not to, and prohibit judges basically from finding that right in the state constitution. And that's because 13 states, Supreme Courts have already done that. I posted something on Facebook just about a week ago maybe, after I read a letter to the editor that I thought was just flatly wrong. And usually on Facebook I post pictures of my children and puppies and flowers. So I don't put a lot of political stuff on Facebook, but that particular letter really kind of got under my skin. So I put a let's get this straight post on Facebook to say this is really what Amendment 1 does, and I certainly think that we should vote for it, and I'll be voting for it.
If assuming Judge Barrett gets on the court and the Chiefs vote isn't a swing vote anymore, would you expect to see more 6-3s and it just gets with the program, or will we start siding them politically?
I think that some of that depends on how many cases they're trying to overrule. I mean, the Chief has already sort of taken a pretty strong position, and that's been to our advantage, by the way, in the Ramos case. I mean, in the Ramos case, there was this big discussion about what's binding precedent. In June Medical, there was a whole nother discussion about what's binding precedent, and it was all about these split decisions. And when there's one person in the middle, what is precedent? What constitutes binding precedent? And that's a different question when it's judges that are below the level of Supreme Court of the United States justice. I mean, they can write their own rules for what they think is binding on themselves. But when we are judges or state judges or federal judges below that level are trying to interpret their cases, somebody's got to figure out whether it's precedent or not. And in Ramos, which involved non-unanimous jury verdicts for decades, courts and judges in both state and federal courts have looked at a decision that was decided in 1972, 1 year before Roe, that said non-unanimous jury verdicts are constitutional. And on the basis of that decision, which had one justice in the middle, Justice Powell, they said that's binding precedent on us. And they left it to the Supreme Court, as they have directed courts to do, to decide when and how to overrule their own precedent. The Chief has been very, very conservative about overruling precedent. And so for us, that was good in one case, and it was not so good in another case. But both of those cases are really having a pretty dramatic effect now, in a different way than probably anybody anticipated. But they're having that effect on the conversation about what constitutes binding precedent. I think the Chief is very conservative on that point, and I think that he's trying to keep everything slow and considerate. And for everybody who's abandoned the Chief to the liberals, I will tell you this: that he said many years ago when he was being considered as a justice, that he viewed the role of the court as not being as involved, not granting, that being less involved in letting these issues percolate at the state level or in the circuit level, and not granting cert in as many cases, was one way to let democracy flourish and keep the courts out of it. Now, it doesn't really keep the courts out of it because they're in it, they're just in it at a lower level. But the court now grants about anywhere between 60 and 80 cases a year, and it used to be 160. So in keeping with his view, he has been a lot more conservative. He has not given his vote to even hear cases, and when they won't hear them, now you've got differences in the circuits. You've got, you know, in our case, we've got a great Fifth Circuit. Cannot say enough good things about them, and I think that's going to be very good for us. If they'll just leave us alone, we'll be all right. But you know, that's not true in every circuit. But when the Supreme Court just decides not to decide, they are taking a very conservative view of their role, and so I think he will continue to do that. I think he will continue to push back on quickly overruling cases. But you know, if he's lost the votes, then we still may see a lot more activity.
I've got a gift for